Let me just talk for a moment about this question of the relationship between decisions by national competition authorities and the courts. In the original draft of the directive, courts were going to be obliged to apply the decision of any national competition authority, whether it was their own national competition authority or that of any other member state. And that represented the existing position in the German courts. This caused a constitutional difficulty for the neighbouring country of Denmark. They wouldn't accept as conclusive a decision of any national competition authority, including their own. And that is why we have the compromise on it being described as prima facie evidence. Now, even if it's a decision of the European Commission, the court has to have regard to two important matters. The first is that the decision is binding in relation to addressees of the decision, and it is binding in relation to those matters covered in the decision. In practice, we have found that causes very considerable difficulties. The first is the difficulty associated with addressees. If you have a cartel which involved a complex group of multinationals, you don't necessarily address the decision to all the members of the multinational group who were involved in the infringement. For example, you have mega corporation, a corporation incorporated in the state of Delaware in the United States. It has a subsidiary in Germany which was involved in making the cartel agreement, and another subsidiary in Romania which applied the prices that had been agreed by the subsidiary in Germany. If the decision was addressed to the company in the state of Delaware and to the German subsidiary, that doesn't bind in an action against a subsidiary in Romania. And that all has to do with rights of defense and res judicata. What that means is that you may have not just what is called a follow-on action, which is a pure action flowing from the decision of a competition authority, but a hybrid action in which some of the facts in relation to some of the parties have been decided by a competition authority. But the same or similar set of facts in relation to other defendants don't bind those defendants because they were not addressees. A further complication arises from the fact that a follow-on action has to be based on the facts found in that decision. And quite often, they will only have looked at part of the, if it's a cartel behavior, in geographical and temporal terms. So they may have looked at the effect of the cartel in Germany and not in Romania. They may have looked at the effect of the cartel between 1998 and 2003, whereas in fact there is evidence that the cartel existed in 1985 and went on to 2005. So you have to look very carefully at what is binding evidence on whom. So that's really a bit of background. The limitation issues, which have already been described, are likely to cause us quite a lot of trouble because you have to follow the rules very carefully, and that also raises the question of whether the private action has to be stayed if there is a public enforcement investigation going on. So that, for example, in our system, a private claim is automatically referred to the National Competition Authority. They may come back and say, we are going to investigate this. You should stay your proceedings until we have finished investigating, either closing our investigation or making a finding. Similarly, the court has to have regard, under the Brussels regulation, to parallel proceedings and to ask itself the question, are the proceedings taking place in another member state so closely related to the proceedings before me that one of us, under the Brussels regulation as recast, has to be seized to the matter and the other actions should be stayed. Quantification. As I say, proof is not necessarily possible. Now, it's worthwhile, if you look at the communication, it's available in all the languages, so you can read it in English or Romanian. But paragraphs 8 and 9, they're quite short, give a very interesting view of the relationship between national law and EU law. And what they recognize is that much of what we're each going to do is going to be done under our principles of national law. That's the equivalence principle, but also that we must be effective. Effectiveness is that applicable national legal rules and their interpretation should reflect the difficulties and limits inherent to quantifying harm in competition cases. In reality, it is impossible to know how market conditions and the interactions between market participants would have evolved in the absence of the infringement. Lawyers may tell you, it's impossible, therefore there are no damages. No, it may not be possible with certainty, but the task of the judge is to do his or her best to produce a counterfactual, to compare that with what happened, and to say that the difference requires compensation. And that really is the task that is set to us. And in this session, we need to ask ourselves, how do you do that? And what help do we get? Well, you'll see on here that there are 3 bits of help. The first is that there's a rebuttable presumption of harm in a cartel. Now, you may say, why is there not a rebuttable presumption in the case of abuse of a dominant position? Well, the key lies in the finding of abuse. It's not illegal to have a dominant position in competition law. It is illegal to abuse it. And if you have abused it, then that implies a theory of harm, and you can draw deductions from that. In your national law, there may be circumstances in which the burden of proof goes from one party to another. To some extent, that is explained in the directive, and to other extents, it will depend on national law. The Commission communication guidelines, practical guide, are there to help you. They don't bind a court, but they're there to help. And as our case law develops, so I expect the guidelines to develop too. And then there's the help from the National Competition Authority. The directive suggests that national competition authorities who do have economists can help courts who don't have economists. Now, in some member states, economists can be appointed to the court. In the United Kingdom, we are about to try to recruit some more economists because we believe we need some more. We only have one person in the tribunal who is trained both as a lawyer and an economist, and he's here and he's retired from judging. So now what we do is if we've got a case with economics, we've got one at the moment on MasterCard, we've got 2 experienced lawyers and 1 economist. And he is the Secretary General of our Royal Economic Society, so he's a very senior economist in the United Kingdom. But if you're not in that situation, you can turn to your National Competition Authority, and I have nudged them about this. So, estimation. Andre? So, what the directive says is that judges must be empowered to estimate. And that's a recognition of the fact that this is not a precise science. Judges, at the end of the day, have to pluck a plausible number from the air. as I said, there's a presumption about, so if we go on to the practical guide, it's not binding, it's meant to be helpful. There will be developing case law. We have developing case law already. You're asking yourself what would have happened otherwise, recognizing that that's got uncertainties. So you create a scenario that seems plausible. Now, I have to tell you that I would like this done by pendulum arbitration. I think it's best to listen to both parties and to ask yourself the question, who has the most plausible argument? But we're a court, and so as a court, you can decide that it's neither of them, and you're going to make up your own plausible scenario. You may like bits from what one party has said, you may like bits from what another party has said, but at the end of the day, if you're the court rather than a pendulum arbitrator, then it's down to you. Part of what's going on in the directive is the possibility of resolution by consent or alternative dispute resolution. And there may be moments when you want to say to the parties, the time has come for you to try to talk to each other or to go before a mediator. So, proportionally determined insights, method, and techniques. Economists may be prepared to do a very, very expensive exercise in which they do extensive survey data. And they produce an econometric model. And at the end of the day, you get a figure which goes all the way from the millions to the cents. But it may not be worth spending all that money. In the MasterCard case before us at the moment, which involves a great deal of money, this is the supermarkets and the charges for credit cards. The problem is that the Commission did some work, but they did the work only amongst certain retailers, and they left out the many, many small retailers. And so the economists are arguing, what happens if we relook at this model to try to incorporate the smaller retailers? And nobody's actually gone out and surveyed the smaller retailers. So you've got this question of theory, empirical research, and is the empirical research relevant to what you're talking about? So what happens if we look at a case? Now, this is where my milk case study comes up. And the first thing I need to tell you is that there is an error in translation from British to European. And I have to confess this up front. In the United Kingdom, we have had a struggle with the measurement system introduced by Napoleon. We are still measuring distances and speeds in miles per hour rather than kilometers. And when it comes to buying milk, we still buy milk in pints rather than liters. And what I realize is that I didn't translate this right, so I've gone and put 4 liters, which would be very heavy, rather than 4 pints, which should translate into about 2 liters. So I want you to imagine that we're talking about 2-liter containers of milk. You also, for the purpose of this case study, have to realize that the milk regulation has come in and you're only allowed to sell milk in one size, and that is the 2-liter size. So, milk is a staple product. So you've got an interesting economic question of how far does people's consumption of milk go up and down depending on the price. Now, there is a question of where do people buy their milk, because in many European states you can buy your milk from the supermarket or you can buy your milk from the convenience store. Now, in my house, the convenience store is 90 seconds walk away. The supermarket is 15 minutes walk away, or I can get in the car and drive the car and have to go in the underground car park and queue. So how much differential in the price of milk does it take for me to stop walking 90 seconds and go 15 minutes walk to buy my milk? What happens at breakfast time when my wife says to me, there is not enough milk for my cereal and my coffee, now, my local convenience store upped and upped the price of milk until they got to the stage where people wanted to walk 15 minutes to the supermarket. Now they brought the price of milk down. Now, why? Partly because if they can get somebody into the shop to buy the milk, then they may buy other things while they're in the shop. So what we are talking about here is some fundamental economic concepts. First, substitution. There are various forms of substitution in economics. My wife is not going to be pleased if I come back from the shop and say, well, milk was very expensive, why not put white wine on your cereal? Or, well, milk was very expensive, so I bought some orangeade and you can put that in your coffee. So in terms of milk, how much substitution? I could buy soya milk or almond milk or goat's milk or sheep's milk. But the reality is that in many ways, cow's milk, people want cow's milk. Semi-skimmed, full skimmed, not skimmed at all, and so on. But for the moment, we'll just talk milk. So, if I talk about Europe generally, the price of milk has been going down. Milk flows freely between member states. So a lot of milk flows, for example, from Denmark into Germany, from between England and Scotland. There is quite a lot of movement of milk. And in the supermarkets, the price has been forced down. Supermarkets watch each other very carefully. We've had a big case about supermarkets, and we can see how closely they watch each other. In Britain, we've also had a cartel case about dairy products and what the supermarkets have been doing about the price of cheese. Now, I don't know about Romania, but in our countries, convenience stores tend to be in groups. And here, in this case study, we've got two different sorts of convenience store. The cost-right convenience stores and the real convenience ones. And the cost-right ones have sacrificed margin because they believe if they can get people into their shop, the people will spend money on other things. So not worth raising the price of milk. On the other hand, the real convenience stores raise the price of milk because they believe that when people are desperate for milk, me at breakfast time, wife pressing me, want milk on cereal and coffee, milk has to be available quickly, they can charge more money for convenience and make a profit. So, look at the market shares. We've got one party with 60% market share, the other party with 30% market share. A takeover. Reference of the takeover to the competition authority, and it's allowed because it doesn't change the number of competitors. Then suddenly, in July 2014, the price goes up. So what do? Well, cost-right maintain their price, but lose their margin, and real convenience increase their price, but they don't entirely pass it on to their customers. Now, that passing on is quite important. In our current supermarket case, the question arises, how far did the supermarkets pass on the cost of paying for the credit cards to their customers, bearing in mind that all the supermarkets were being charged the same? And you have to ask yourself that question. So then you have a leniency application. Now, we heard about leniency applications before, and leniency applications under the directive have certain consequences. We're not going to go into those now. You'll find other materials about leniency applications on the website. But they went before the Competition Authority and said that they had been threatened. This is Sudmilk, said they were threatened by Normilk. There was a raid, and you get some evidence from the raid, but not complete evidence from the raid. Some cartels are very kind. They leave emails around saying, I think of one particular case, we better not ask the lawyers because this is a cartel. That is not entitled to legal privilege, that email. You'll see that they lower their price. Now, that's important because we've now got time bans for this infringement. And in this case, they're nice and clear. Starts in July, goes on until March. Then they go to the other party, and the other party has a different story. Now, this is not uncommon. So, there's a decision. So you've got a decision. The decision is addressed to these three parties. Now, under the directive, there is joint and several liability. You can sue one cartel member for damage caused by any cartel member. There can then be, this is, again, we're not going to cover this today, but you can have contribution proceedings between the parties to work out who pays for what. And there are certain provisions in the directive about protections for the leniency applicant and when they don't apply. So in this particular country, there's a specialized competition law bar and a specialist market court. Now, this has raised an interesting question in Europe about how many judges are trained in competition law and how many judges hear competition law cases. In one member state, 1,000 judges have been trained, but only 3 judges hear competition law cases. When the European Commission conducted a survey on the training of judges, I think 187 German judges replied and only 8 British judges replied. And people said to me, why so few British judges? Well, answer, because in England and Wales, very few judges are allowed to do competition law cases. You can't go and do a competition law case in a local court. It has to come in England and Wales to the Chancery Division, that's a group of 18 judges, or to the Competition Appeal Tribunal. In Scotland, you can go to any one of 50 different courts and about 150 different judges, most of whom know nothing about competition law. One judge does, actually. So you have to decide, do you go before him or do you go before another court to find a judge who really doesn't know what he's talking about? So, interesting question. And one of the things that we're going to have to see how it develops in Europe is how far do we develop specialist lawyers and how far do we develop specialist judges? So, basic economics. Substitution. You have to ask yourself, if I'm not going to buy milk in the supermarket, I buy milk in the convenience store. And in this country that we're talking about, those are your options. No house-to-house delivery of milk, just those 2 options. Is there a substitution for milk? Are there other things, sheep's milk, goat's milk, or are they actually so much more expensive that people are not naturally going to switch unless the price of milk goes up a great deal? And you have to ask yourself, at what point does the price of cow's milk get so high that people switch to sheep, goats, or whatever? Price elasticities. Now, this is a little bit of economics. What a price elasticity says is if the price goes up by 10%, what happens to demand? If the elasticity is 1 and the price goes up by 10%, then demand falls by 10%. And if you're to get from what actually happened to the estimated counterfactual scenario, then understanding elasticities is quite important. In a case like this, what's called cross-elasticities matter. And what that says is if the price in one place is 120 and the price in another place is 60p higher, and that then changes, how many people go from the convenience store to the supermarket? And sometimes you'll have evidence of cross-elasticity, and sometimes you won't. But you have to think about cross-elasticity as you go along. So that's differential price cost elasticity. So we go on to 3, use of analogies and counterfactual scenarios. In England and Scotland, when we had the milk problems, the milk cartel in Scotland, you could tell very clearly 2 things about milk in Scotland. One was that the company Robert Wiseman was immensely profitable compared to dairies in England, and the other was that the price of milk in Scotland from convenience stores was considerably higher than it was in England. There is no barrier to milk going across the border, and this gives rise to an immediate question, why? And an immediate counterfactual, well, look at the prices in England and the profitability in England and say, if England is a competitive market and in Scotland there was market sharing, so a non-competitive market, then you've got a pretty good counterfactual with which to start. And here you've got neighbouring countries, and it would be quite natural to take a comparator of the neighbouring country. Of course, you've got to think about differences in markets and whether the input costs are the same, but here that would be a good comparator. You can also look at different time periods. The time period before the cartel, the time period during the cartel, the time period after the cartel. And if you look at the Commission's practical guide, you'll see nice graphs and how you do that and how you look at that and how you take into account that during that period things may have changed. It may have been summertime during the cartel, wintertime outside, and you look at patterns of how prices have changed normally during the year because some products are seasonal, and you compare different years and so on. Maybe the European Commission introduced a subsidy for milk. So you have to consider that as well. So then you've got to say, well, what are we looking at in terms of the damage? Well, in the case of Costrite, they didn't change their price. So there you're looking at the lost profit from having to pay more to the cartel. But what about Real Convenience? They were paying more, but they increased their price. They passed on half the increase to their customers. Now here you've got to ask yourself more questions. One, what did it cost them to pay more for the milk? And what would it have cost them had there not been a cartel? How much of that cost did they pass on? How much did they bear themselves? But in both cases, you may have to ask yourself, what happened to their overall income because of what happened? Now here, you can get evidence from the till rolls. How many people just came in and bought milk, and how many people came in, bought milk, and also bought the newspaper and some chocolates because they were right by the till, and an Easter egg. What was going on in reality, and how far did these changes impact the overall income of the shops? And to some extent you'll get evidence on that, and to some extent you will have to work that out for yourself. So you may get expert evidence, and then you have to look at the time period and ask yourself, how do you apply interest? Now, in these days of very low interest rates, and in some countries negative interest bank rates, that's an interesting question, and your national law may well tell you what interest rate you apply, and there's recently been a study right across the European Union on how member states are doing that. What's important is that you have to think about it and to ask yourself the question, what is the right interest rate to apply? So, where does one look for help? The practical guide we've already mentioned, economists. Sometimes the parties will produce economists. Sometimes the court may appoint an economist, either as a judge or as a special advisor. So, for example, there's another jurisdiction where I am on call as a special assessor to the court. So if the judge feels that he's getting out of his depth, he can ask me to go and sit with him and help him. And sometimes you can turn to the National Competition Authority. Most companies have accounts. Be careful. Accounts are accounts, they're not economics. And we have companies who come before us and they say that we were done tremendous damage, just look at our accounts, we're deep in loss. And when you look at the accounts, you discover that one of the reasons they're deep in loss is that the family shareholders have paid themselves an enormous dividend and the directors have taken enormous fees. And you have to ask yourself the question, is the reason for the loss the damage caused by the cartel or the damage caused by the way the family have managed the business? And if you want to look at a case like that, look at our Cardiff bus case, at arguments about what caused the damage when a company is put out of business. So be careful of accounts and accountants. But they may be the place you have to look for detail. And you may want to look at the management accounts. You may want to look at what was going on with the pricing behavior and the quantification. You may want to look at the accounts, the supply contracts. You may want to look at what was actually going on. And that's often where the quantities are. So you've got to ask yourself, where is the information readily available and what information am I going to have to produce a plausible answer for? Now, part of the difficulty, where costs are variable and where costs are fixed. If you're a small shop, it's very unlikely that even if milk goes down in sales, you're going to sack the staff because you've hardly got any staff. You can't make the shop smaller. You've got to go on paying the rent and the taxes and the heating bill and the water bill. They're fixed costs. You can't get rid of those. The cost of the milk coming in varies, but other costs don't vary. So you have to consider that. You can look at parallel cases sometimes, and you can use your common sense. The practical guide gives you various ways of looking at things. Now, I don't want to go into a lot of mathematics or algebra today. The economists can help you with mathematics and algebra, and sometimes they will confuse you completely. I have to tell you, if they can't make you understand what they're talking about, then I would be reluctant to trust them. There are moments when economists have come before me with wonderful models, and I've said, but that doesn't actually work in real life. Just look at the circumstances of real life. Don't be afraid to put the actual situation to economists and ask them whether their theory actually describes life as it is. Regression analyses, again, here you're dealing with what variable matters and what other variables are going on. We've already talked about the time of year. Sometimes the reason why consumption goes up or consumption goes down has nothing much to do with the behavior of the cartel and everything to do with whether it rained. And sometimes you will have to look at the normal effects of rainfall or cold or warm on consumption and not just the effect of the cartel. And regression analyses can help you to determine which variable was affecting the way in which demand developed. Simulation, again, you can do simulations. You can look at behavior but that all requires assumptions. And you have to ask yourself, how do I deal with these assumptions? In our MasterCard case, as I said, the Commission had done a survey, but it only looked at certain sizes of retailers. And the argument amongst the economists was, what assumptions do I make about smaller retails, bearing in mind that the survey data was on larger retailers? So simulation, you can do that. Now, in the case of supermarkets, in my recent supermarket case, I asked each witness how much quantitative modeling did they do in their supermarket in terms of pricing. Only one supermarket was doing quantitative modeling. The others were all, well, it wasn't quite like that. It was, well, what are the others charging? We'll just nip round and see what our competitors are charging, then we'll adjust our prices. Now, that was a case where part of the problem was that the suppliers were saying to the supermarkets, well, if on Thursday you raised your prices, don't you worry, because prices might go up in your competitors on the same day. And also there, and this is back to accounts, what was discovered was that what was on the invoice pricing wasn't the whole story. It turned out that there were a whole lot of things going on off invoice. And so you've got to be careful with the evidence to discover whether what appears on the face of the record is actually what's going on or something else was going on behind the scenes. And quite often the emails will reveal what was going on behind the scenes because people aren't careful enough. Overcharge, passing on, and volume effects. So overcharge, that's when the price goes up and maybe pass through to consumers. So sometimes the entire damage has been done to the consumers in terms of the price change, but a volume effect has hit the retailer. So they put up the price and therefore their volumes fell. And they're entitled to recover for the loss of that volume, even though they can't recover the price they passed through. Exclusion. This case study doesn't involve inclusion, but you have to think about what happens in exclusion. Comparators. Sometimes, and this is a case, you can look at before, during, after the cartel. And sometimes it's very clear what's been happening in the behavior. In our tobacco case, you could see the changes taking place. That was a case where we had supermarkets and convenience stores, and one of their defenses was, we were so bad at this, we weren't terribly good at implementing the cartel. And sometimes you'll have a defense like that, and then you've got to look at the detail and ask yourself, were they implementing the cartel or weren't they implementing the cartel? In our tobacco case again, the suppliers of tobacco said that they weren't price fixing, they were merely providing clerical assistance to the supermarkets by providing them with a large spreadsheet with all the products down one side and all the prices, and that was only clerical assistance, it wasn't price fixing. Ask yourself what's going on. These are time sequences, and you can look at what happened to the prices over time and what is the evidence of the cartel. Data from other geographic markets. In this case, you've got a neighboring geographic market, and you can ask yourself, were the prices moving similarly or were they moving differently? Data from other product markets. Sometimes you'll have a situation in which, for example, the price fixing is going on in white wine, but red wine is unaffected. And you can ask yourself, why? And sometimes you've got a combination of these different things. Counterfactuals. So what you're trying to do sometimes with the help of the parties and sometimes with them trying to complicate matters, is you are trying to come up with a straightforward what would have happened if these parties had not misbehaved. Don't allow the parties to make this impossible. Don't allow the parties to make this uncomplicated. There is a presumption of harm in a cartel. You are entitled to say, this is what I think would have happened. If you are extremely wrong, you'll probably be taken to appeal. But have a go. Use the evidence, recognize it's incomplete, be courageous, go for it. Plausibility. From your very early age, I have to tell you, you have known whether the story that Mummy and Daddy were telling you was plausible or not. It's one of the first things that children learn, is to tell the difference between a plausible story and a non-plausible story. You don't have to be a judge to tell this. You're a human being. Plausibility is built into who we are. This is not, there's nothing esoteric about this. You can look at the situation, ask yourself, is this plausible? And if the parties are giving you a story which is implausible, it was pure chance that the prices all went up on Thursday, they may be right. There are times when they are right, but sometimes they're not. And use actual comparators. Don't be frightened to say, well, the nearest comparator is the neighboring country, and this is what happened in the neighboring country. Passing on defense, the directive tells you that the burden of proof passes to the defendant. In this case, it's very clear. In some cases, it won't be so clear. The burden on indirect purchase is conditional, and I'm not going to go into detail. If this happens to you, the parties will take you through the directive and explain where you should be, and that tells you where to go and have a look. Interest we've talked about, and it can be a large component, particularly if there's inflationary times. At the moment, we're not in a great inflationary time, but that is. Multi-level claims. You may be in a case where a collective action is brought on behalf of consumers as well as an action by the retailers. And you may have to think through how you handle that. In a sense, that's helpful because you've got everybody in front of you and you can work out how the damage should be apportioned between the two. I was part of a collective action in California, and when I claimed my damages against British Airways for having fuel surcharges, I was told I couldn't have my damages because my travel agent had already claimed them. My travel agent probably made a lot of money from people not realizing that they were making claims. Now, that was a passing on case where they failed to do a passing on defense to say, but you passed on all these charges to your customers. If they'd looked at the documentation, they would have seen lots of documents with ticket prices which said fuel surcharge. And I eventually recovered my money from the travel agent, but many people will not have done. So, actions for the same infringements. Courts got to be alert to the fact that you may have cases going on at different levels in different jurisdictions, and you have to ask yourself, how do these relate to each other to ensure there's not under-recovery or over-recovery? So public information on public enforcement is important. Contribution. So this is a case where we've got three parties, the action's been brought against one party, and at the end of the day there may be an argument about which party pays how much to whom. Sometimes you will have a matrix of actions, many claimants, many defendants. Sometimes you'll have an action brought by many claimants against one defendant. Sometimes you will have a very complicated matrix, and you have to manage that. And having done some of these complicated questions, your problem is what happens when some parts of the matrix start settling. And you have to work out who has settled what. And if it involves more than one court, you may find yourself needing to communicate with the judge from the other court to work out which bits of this action are still alive and which bits of this action have been settled. Now, this is the awful reality, and it can become quite complicated. In my Emerson action, part of the action was taking place in the United States, where it had been consolidated in front of a single judge. He wasn't always quite clear what he was deciding. And that was a case in which we admitted the American trial lawyers to come and appear before us to try to explain to us what was going on in America. And you may want to admit lawyers from a neighboring member state to come and explain to you what is going on in the parallel proceedings. But at the end of the day, contribution is how you work out which cartel members end up paying how much. What's important in the directive is that that does not impact on full compensation for the claimants, provided somebody is still solvent. And you have to look at immunity recipients as well. Consensual resolution. This is a slide which is almost blank because this is what happens when the parties sort it out. Now, in our law, if it's a collective action, that has to be brought back to us for approval. We have a collective settlement procedure, which is then binding on those who don't opt out of it. In other words, parties have to decide, are they going with the settlement or do they want to carry on with their actions? Again, you may have to sort that sort of thing out, but it helps a great deal because then you don't have to do any of this quantification. They've done it for you. But you may have to show that it's reasonable. Judgments. You make the award, it's got to be enforced, you've got to ensure they actually pay, you've got to inform the commission of what's happened, and you've got to deal with costs. That's a matter for national law, so I'm not going to discuss. You'll be much better at saying how you deal with costs in Romania than I am. So, going on to the next slide, effectiveness and equivalence. This is back to the basic principles. So hopefully somebody is working away on your national rules so that by the time we get to the end of this year, Romania and the United Kingdom and all the other member states will have national rules which enable us all to do this. And they have to ensure that it's not excessively difficult or practically impossible to exercise the right to compensation. So, I don't know how many of you have read the case study. I also don't know how quickly any of you are going to receive a claim. What I hope we've done, both today and more importantly on the online resources, is to put in place a variety of materials which help you to tune into the sorts of questions you need to ask yourself when that claim arrives at your court. In our case, it often arrives in many boxes full of paper. And you have to grapple with the paper and ask yourself, what questions am I asking of all this paper? And is this enough paper or do I want some more? So over to you to discuss this part, and then we'll discuss the whole program and how we make it more helpful to you and to those right the way around the European Union. So think not just of yourselves in Romania or us in the United Kingdom, but the small countries like Malta and Luxembourg, and the big countries like Germany with many judges, the countries like Scotland with many courts and many judges, the countries where it's specialist like Portugal. What sort of help can we give each other? And what questions have we raised in your minds?